language. Jeff, if you can advance. You want to make sure you're selecting your language preference. So if you want English, select English. If you want Spanish, select Spanish. Aquí está la información, va a aparecer en su pantalla abajo donde ve la información de participantes y más información. Va a haber un globito. Ese globito va a escoger el idioma, va a escoger Spanish si lo quiere en español y lo va a poder escuchar en español. Next slide. So congratulations, you should be able to hear the presentation in the language you selected. If you're having trouble, please write a message in the chat function and we'll provide assistance. Si no está escuchando esto en español de la presentadora, entonces por favor, mande un mensaje por chat. Thank you, Jeffrey.
Thank you.
So are we ready to go ahead?
Yeah, we're good, Paul and Jeff.
Okay. Okay, thanks. And just a question, Jeff, do you need to advance the slides or are we sharing?
I think I will be advancing the slides.
Okay. Sorry, I was just trying to figure out if I might have access to it too, to share. But anyhow, let's go ahead. Good morning, everyone, and thank you for joining us today. I'm Paul Lind from Errant Fox in our San Francisco office, and I'm here with my colleague from Jeff Weston, who's with our Los Angeles office. And I just want to thank AgSafe for hosting us today and inviting everyone. And I've worked over the years with AgSafe a number of times and presented at the conference and some other webinars on sick leave issues when that law went into place, and also made some other presentations for AgSafe. So it's really great to be working with the AgSafe community again. So again, thank you. This topic here about California family medical leave issues, just by way of a short introduction. One reason that we thought that this would be an important topic to cover with a webinar is among all of the issues that California employers have had to deal with in the past year, and there have been a lot of them, COVID issues as well as, and things that stem from that, as well as the normal issues. One of the things that happened last year is the California legislature passed legislation that significantly expanded the California Family Rights Act, which is the state federal, it's the state equivalent of the Federal Family and Medical Leave Act. And it made a significant expansion of the requirements there in terms of who is eligible and the reason that someone can take leave. And with everything going on last year, this is actually kind of a sleeper issue that's been out there that kind of flew under the radar. So on top of everything that you all have to deal with, there is this thing out there. So we thought that this would be a good topic to present on. And as well as I can tell you in our practice over the years, there's always been continuing questions about FMLA issues. It's one of the more challenging aspects of employment law. And a lot of times people, it gets complicated. Things just run on autopilot with a checklist on this thing. Things come up, there's all kinds of variations. And people end up having to consult outside counsel, their legal, their law firms, their attorneys, all the time on these things. So it would be good, we thought, to give an update on what the California changes are, kind of where the law stands, what people need to look at and anticipate and the law is in effect now. So you need to actually be prepared to be implementing this now and complying. But it was also a good opportunity to give a refresher about California and federal family medical leave requirements. And also talk also about as they relate to COVID and some things that have happened that may be on the horizon there. Among the reasons why is this so significant is one of the changes that California made. Many of you may know for FMLA and for CFRA before you had to have at least 50 employees within 75 miles. Now it's down to 5. And so what happens is this is probably making an estimated about 6 million employees in California eligible for family medical leave who were not eligible before. And so what's going to happen is you have a lot of employers who never had to think about these issues before to comply are now having to do that. And it also affects everybody too. Even people who were subject to the law before are going to have to make some changes because it significantly expanded the possible uses of California family medical leave. So actually, Jeff, I'm sorry, could you go back maybe a couple slides? This is actually, I think, the third one. Or it's the second or third. Here we go. Okay, thank you. Okay, just by way of overview, kind of how did we get here? How has the California Family Rights Act and the federal FMLA developed? Believe it or not, California actually had a state, the California Family Rights Act, so a state FMLA law before the federal FMLA came into place. California enacted that in 1991 and it was effective in 1992. The federal FMLA did not come into existence until, maybe you may remember, 1993. And just a bit of the history, some of you who are older may remember this. It was a very controversial idea because there are arguments that this would be a significant burden for businesses, which it is. I mean, let's be honest about it. And for smaller employers, when you have just the smaller ones, 5 and up, that, and having someone potentially offer up to 12 weeks a year, that is going to be a lot to work with in some cases, and to figure out how to manage that. So one of the issues that was a huge issue with the CFRA and also FMLA was what is the minimum level of employees that it should cover. And originally the proposals for the FMLA were to cover at least 25 employees. Again, the employer had to have at least 25 for the law to apply to them. What happened was that the number got pushed up, thinking that this would be easier for larger companies to comply with as opposed to smaller ones. But what some of you may remember, when the first President Bush was in office, he had vetoed this, the federal FMLA twice. Okay, so at the same time that that's going on, California enacted the CFRA. Originally, as enacted, the CFRA provided for 4 months of family medical leave with every 2 years, okay? And what it did was if you took pregnancy leave separately from that, you could take an additional month of family medical leave every 2 years. So what happened, some of you may remember this too, after President Bush left office, then President Clinton came in and he had indicated he would sign the federal FMLA, and Congress got it to him and he signed it after about 2 weeks of being in office. So I think it was the first bill that he actually signed. So then what happened that same year, California amended the CFRA to conform largely to the FMLA.
I'm so sorry to interrupt. I just handed you control, so if you want to move the PowerPoint where you need it to.
Okay. Should we both be able to advance this?
No, just you.
Okay, using the arrow buttons or?
Yes.
Okay, because yeah, it doesn't seem to happen.
Let me see.
There it did. Okay, or I think. Will it move? Okay, well, I'll continue. So in addition to the provisions you have in the law, what's also important too is the regulations, okay? And what happened was the Federal Department of Labor adopted regulations in 1995 that talked about how to implement the FMLA, and that's really where a lot of the details of the requirements get filled in that employers need to be concerned about. So California had its own regulations that had been adopted for CFRA, which it then changed, and so they largely conformed to the federal regulation, but not in some key areas. That was there was confusion for years in the law about that. When you get to, it was early 2009, right before the second President Bush left office, the federal DOL did an update of the federal FMLA regulations, which are actually still in place. They have not been changed significantly at all since then. And that update actually made a lot more things more clear. And so California's regulations then were still different. What happened after that, about 10 years ago, I think it was around 2012 when they went into effect, California updated its CFRA regulations to where they stand today, so that they largely conformed to the FMLA, and it really did clarify a lot of things. So we'll be talking through this about what the CFRA requirements are, and also the FMLA requirements and how they're different as we go along. Okay, looks like maybe I do have control of this. Okay, so what are some of the requirements in general here? Under the FMLA and the CFRA, they generally have been similar. A covered employer, and that's if you've had enough employees to be covered, had to provide up to 12 work weeks of FMLA leave in a 12-month period to an employee. And the employees, of course, can take it in a block. You could take all 12 weeks at once, which some do. And then you also could take it intermittently. And that happens sometimes. For example, someone may take 2 weeks for surgery. And then later they may have follow-up treatment, so they take another 4 weeks. But you can take it in increments like that, and it adds up to 12 weeks a year. Another way intermittent leave happens is you may have someone that's taking a course of treatment, for example, chemotherapy, and they're taking it like every Monday, or they take it for a couple of weeks and they're off. And so it could be things like that. You don't have to be done all at once. The leave is unpaid. That was one of the things too. This was not a paid leave mandate, but employees can choose to use any paid accrued leave that they have, such as vacation, sick leave, floating holidays, personal days. Some of the leaves in California would qualify for SDI, for state disability insurance benefits. If it also qualifies as a disability and it's not work-related, it's your own condition that could qualify. Or also, we have a paid family leave benefit in California for leave to care for certain family members. And so if they're also covered by, if paid family leave benefits cover that family member, you're taking leave to care for him or her. And also, it's covered under CFRA, you could be eligible essentially for paid leave that way. Okay. So the leave is unpaid, but what about an employee's benefits? This is actually an important issue. The group health benefits, they have to continue during the leave and on the same terms. What this means is, let's say the employee takes 3 months off, the 12 weeks. Their health benefits would stay in place. Let's say they normally pay like a copay of $50 a month or something like that. They would still have to pay that for the benefits to continue. And sometimes you have to make arrangements with them about how that would be done. They send in a check, or sometimes if you're continuing essentially to pay them, they're like using their sick leave or their vacation, you can deduct it from those payments. What happens sometimes is companies don't take that, or they just keep the benefits. They don't get the money, or they're not deducting it. And what happens is then basically the employee owes them when they come back, and you have to figure out ways to get that back in a legal way. You can't just go deduct it in a lump sum without authorization when the employee comes back. So you need to make arrangements with them or get an authorization. Now, at the end of the leave, an employee is entitled to reinstatement, and we'll cover in a few minutes just exactly what that means, because it's not just reinstatement to anything. There's some particular requirements that have to be followed. And this is the important thing too. There can't be any discrimination or retaliation for having taken family and medical leave. Okay, now who has the FMLA and CFRA traditionally covered? As I mentioned, you had to have at least 50 employees within a 75-mile radius for it to apply. And I can tell you, the 75-mile radius is something a lot of companies just ignore, or they found it hard to administer. But it doesn't necessarily mean that you just have 50 employees anywhere, or within Southern California or within the state. You could have, say, 20 in Southern California, 30 in Northern California. You may have 50, but you wouldn't have enough close enough to be covered. Okay, and so this is one of the things that has changed because it's going down to 5, or it has gone down to 5. To be eligible, it doesn't mean that just because you're employed at the time that you're necessarily eligible for FMLA. You have to have been employed for at least a year, and then you also have had to have worked at least 1,250 hours in the past 12 months. And that's not just talking about 1,250 hours in the first year. The way the law and the regs are written is you actually have had to work 1,250 hours in the previous 12 months before you take the leave. And this does come up sometimes, especially if you have employees that have been on leave before, like in the previous year, and especially if they had an extended leave even beyond their FMLA and didn't work as much. And you look back and they have not, they in total meet the year requirement, but they have not worked 1,250 hours. So you have to look at, you know, are they eligible for some other type of leave or just not eligible at all too? It can be difficult. Now, potential pitfall, I've seen this happen a few times over the years. You may have an employee that has the 1,250 hours, for example, that is in the first year of employment, hasn't hit the 1-year anniversary yet, and needs to go on leave, let's say for that employee's condition. You know, now if someone isn't eligible for FMLA yet, what do you do? Are they out of luck? Not necessarily, because the leave could be a reasonable accommodation, you know, if the condition qualifies as a disability. So you could end up having to give that to them. And so they start their leave, and then what happens, let's say they're 11 months into their employment. We've seen this happen where the employee then is out for, you know, 2-3 months, and a month into their leave, for example, they hit the year mark. Well, what happens? They now have the 1,250 hours and a year, so now, boom, suddenly, even though they've been on leave for a while, they become FMLA eligible, so the leave has to start then. So you have to, you know, take care of, you know, designating that, getting a certification if you want to, and, you know, guaranteeing the reinstatement. So what are the reasons that someone could take FMLA or CFRA? And this is how it's been. We'll talk in a minute about how it's expanded. And if you can see here the comparison, the laws pretty much have overlapped. The first one, for the employee's own serious health condition. Also to take leave to take care of their child's serious health condition. And at the bottom too, to care for the serious health condition of a parent or spouse, okay? What does serious health condition mean? The regulations define this, and it can mean a couple of different things. Basically, it doesn't mean minor ailments, a cold or a flu, but it can mean something that requires a course of continuing treatment, or something that, you know, could involve an overnight hospital stay. It doesn't necessarily have to require hospitalization. But, you know, it is a pretty broad definition. You have to bear that in mind. And the good news is we'll talk about, you know, what proof you can ask for, certification, stuff like this. That's the definition. The thing is, you don't, as an employer, you don't have to be in the position, fortunately, of having to decide, does this person actually have a serious health condition that qualifies? Because in California, we'll talk about this in a few minutes, you don't really have the right to find out what it is. You can get a certification where the doctor says this person meets the definition. So they look at that. So, and you really don't know what the condition is. They don't have to disclose it. The other thing where FMLA and CFRA can be used for is the birth or placement of a child, which is basically baby bonding leave. Okay, and some differences though. Under FMLA, pregnancy qualifies as a serious health condition. CFRA, it doesn't, okay? Here's why. As many of you may know, in California for a long time, we have had a separate pregnancy leave under the Pregnancy Disability Act. It gives an employee up to 4 months for pregnancy leave when there's, you know, before they have a child. And so that existed before the CFRA and FMLA was enacted. And what the legislature in California did was say that if someone is out for pregnancy, it can count on the FMLA, but it doesn't count under CFRA. So they take the pregnancy leave and then have the CFRA leave still available after that for baby bonding leave. We'll talk about this later about how to sort that out. Military exigency leave. And this is something probably most people never heard of and never had to deal with, and maybe never will. It basically is a leave that's existed since about 2008, 2009 under federal FMLA, where if you have a family member who's called up for military duty and service and you need to step in to take care of the family, they could qualify. And I've only had this come up, I think, once, maybe twice over the years. And it turned out the person ultimately didn't qualify. So the employer didn't have to give the leave. And then what we've seen this year under federal FMLA, expanded FMLA for COVID-19. And many of you may have had to deal with this. This was actually an expanded reason where someone could take it if they had to quarantine or had to isolate, to avoid exposure or exposing others, or if they had to be taking care of someone, who was in that position or who was sick. Where it was also used quite a bit is where schools being closed and the employees had to be off to take care of their kids. They were eligible for that, which has now gone away. It actually expired at the end of the year, and we're waiting to see what will happen in Congress about extending that, which it does like looking probably will happen. But right now, that has gone away. The other big California difference that we have had is California CFRA for a number of years have covered people who are has covered state registered domestic partners, which means if the employee has one that's registered with the state of California, it's treated the same as a spouse, and the employee could take that leave to provide care for the serious health condition of a registered domestic partner. One note too, when we talk about you're taking leave for these family members to care for them, the law really means that. There's actually case law in California too, that says it's not just the fact that you have one of these relatives, a parent or a spouse who's sick, and you just want to visit them and be with them. And you have to be providing care. So that's one thing to look out for to see if someone actually qualifies when they want to take leave to care for a family member. Okay. One baby step that happened a few years ago, effective in 2018, is California had been, the legislature over the years had looked at expanding family medical leave in California by reducing the number of employees you had to have, going below 50. And they did try to do this in increments. And one thing that did get signed into law when Jerry Brown was governor and effective in 2018 was the new Parent Leave Act. And basically what it did was it lowered the threshold for taking baby bonding leave to employers that have at least 20 employees. So some of, at least, if you hadn't had at least 50, but you had at least 20, you've had some experience perhaps in dealing with this, at least for that reason. One thing that's interesting, I'll note too, is a couple years ago, before Brown left office, the legislature did pass essentially the same bill that they did this last year to lower the required number of employees down to 5, and Jerry Brown did veto that. He said that this was not consistent with federal law and would be confusing to administer and burdensome for employers. But Governor Newsom felt differently and signed the bill that we're going to talk about today. So Jeff, I'll turn this over to you.
Yeah, so a common question that we receive is the reinstatement obligation and what employers have to do in order to reinstate employees that have utilized the FMLA or CFRA leave. So what this means is they need to be reinstated to the same or comparable job. Now, the question always comes up is, what does comparable job mean? And FMLA and CFRA have kind of identified some of the factors that should be looked at. And the main point that I want to make is employers should think virtually identical. So the job should be virtually identical. So one example is a nurse, right? If a nurse takes FMLA or CFRA and comes back, he or she needs to be reinstated to his or her position as a nurse, right? So it couldn't be a different job. And then some of the other points that need to be viewed when reviewing the reinstatement obligation are, it needs to be the same pay and benefits, same working conditions, same or substantially similar duties and responsibilities, same or substantially similar duties, skill, effort, responsibility, and authority, geographic location, shift and work schedule. So oftentimes we'll see an employee that will return from FMLA and maybe his or her day shift has been removed, and so he or she gets transferred to the night shift. That wouldn't be the same comparable job, and so that would be flagged. And this is mandatory. So there's no undue hardship, there's no undue burden exception. Oftentimes we'll receive questions about that saying, it's really difficult on us because we have a lot of work and we have a lot of obligations. We really have to reinstate this employee. And the answer is yes, you do. There are limited exceptions that I'm hesitant to even discuss because they're very unique. But one of them is just downsizing. If the employer is downsizing their employees and it's unrelated to FMLA or CFRA, then that's okay. But with that, there is case law that says if the employer requested FMLA or CFRA before the downsizing, then the employer may still have to provide the FMLA or CFRA leave. So it's a very, very limited exception. And one question that we get is an employee is out on FMLA or CFRA and the employer decides, can I terminate this employee? So the general answer is no, right? Because that sets up a pretty clear retaliatory claim, retaliation type claim, potentially discrimination type claim. And so we generally advise to avoid that. Now, there are certain circumstances where that could be an option, but those circumstances are pretty unique where there's an employee safety issue, there's the issues are well documented, very, very well documented, and is unrelated to the CFRA and FMLA leave. But the general rule should be if an employee is out on FMLA or CFRA, that employee should be reinstated to the same comparable or comparable position.
Yeah, and Jeff, just one note I'll say, because we've seen this over the years, different things happen. Sometimes some of the members of the audience may have seen this. You have employees who may feel the end is coming and they're going to be terminated or there's performance issues, and rather than deal with that, they go on leave thinking they're going to prevent you from doing anything with them. And basically you end up holding the issue and bring them back and then deal with that. You don't necessarily terminate them when they're out. Bring them back, give them the leave, reinstate them, and then deal with the issue is really the way to go. But you really want to have everything documented. And what you want to show is, you know, we had made this decision before. We would have made this decision anyway. Sometimes you find things when the person's on leave, and it's something that regardless of the leave, they would have been terminated. For example, I had a case a few years ago where they did find there were some safety concerns and some misconduct concerns. And when the employee came back, she was not returned to the assignment she had. And the reason was that the client had actually insisted she not be allowed back. And she filed a claim with the DOL, and there was a whole investigation. And so we had to prove this, and we actually had a statement from the client, you know, saying the problems they'd had, and that was the person was not allowed back. So that's why she didn't get her same position back. And the DOL ultimately found that, yeah, this had nothing to do with the leave, but you got to have that documented, really.
The key is documentation. Thanks, Paul. Seasonal and temporary employees, this will come up often. So oftentimes seasonal or temporary employees, they won't hit that threshold of 1,250 hour eligibility requirements, but the FMLA does not need to have them work consecutively necessarily. So if they previously worked for the same employer, including seasonal work, then that time could be counted to meet that threshold of the 12-month requirement. So just wanted to keep that in mind. Keeping track of hours again, for seasonal and temporary employees, because they might come and go, there could be an issue with keeping track. So just making sure that their time is also tracked so that you're aware of when they might be eligible for FMLA or CFRA. Return to work, same kind of reinstatement obligations, and then joint employment. And where we see joint employment is calculating or determining the number of employees to meet that threshold. So Paul had mentioned earlier that FMLA threshold is having 50 employees within a 75-mile radius. And so the joint employment aspect will come in order to determine whether there's 50 employees. And so looking at it from that perspective. So those are just issues. Yep, go ahead, Paul.
Yeah, and Jeff, one complication too, when you have, you can have a number of joint employment relationships in a lot of industries, and ag's one of them too, where you've got people, they may be assigned to your operation from a staffing agency or probably a contractor. And, you know, the question is, you know, could they be considered joint employees? You know, you may not think they are, and there may be legitimate arguments that are not, but who is responsible for handling all these issues? You know, giving people the paperwork and approving it and designating it and everything like that. And usually that you should look at probably who is the primary employer or who's actually the employer, be it a farm labor contractor, or if there's a staffing agency. Where with a staffing agency, you're more likely to have joint employment. It usually would be the staffing agency. You could look at basically who's paying them too.
Exactly. Okay. So are there exceptions to FMLA and CFRA? The answer is no. They don't contain exceptions. There's no exceptions to certain businesses or organizations or industries or jobs. We'll get those type of questions where employers are looking for exceptions, because oftentimes following FMLA and CFRA is a complicated question, but there are no exceptions. So essentially, if an employee has worked enough time to be eligible, has the qualifying reason, and provides the required certification, then the employer must grant the leave. And so there's really no discretion. Like I said before, there's no undue hardship exception. And then just the one point I wanted to highlight on this slide is that last point, whereas beware of anything that could be deemed interfering with, discouraging, or denying leave. So oftentimes we'll see, or not oftentimes, but we have seen where employers will bargain with their employees, say, can you just finish this project? Can you just do this before you go out on leave? Sometimes there's arguments with employees regarding kind of the workload and their leave. And so I just wanted to raise a flag with that and say, just beware of that type of behavior, because that could come back to haunt employers. So the bargaining, the arguing, the interfering, the discouraging, any type of that behavior should be avoided.
Right, and Jeff, just some other things we've seen too, by way of example, and you know, let's be honest about it. You know, some people have important positions, and there's certain projects or tasks that really that person, you know, is the one that can do it, and others really can't. But you still don't really have a choice, like you were talking about. And some of the things we've seen is like when someone's like, they bring a doctor's note and they say they need FMLA. Oh, well, you know, can you start this next week, not this week? Or, you know, we can give this to you, but not on Friday. Okay. Or I've seen where they had a project that had to be done, run a report, and actually called the person and, you know, wanted them to, you know, do something for a couple hours. When someone's on leave or they say they need leave, they're on leave. You shouldn't be doing that, because that just is walking right into an interference claim there.
Absolutely.
Okay. And actually, the one thing too, actually, you know, that comes up too, when you have people, because a lot of employers have people who are on intermittent leave, and there's a lot of question about that, especially because people get things that say notes or certification that say, you know, basically this person will need it as needed when the condition flares up or something. And so you have no idea, and they say it could be like 2 occurrences a month for up to 1 to 2 days at a time. You may have to grant on that, okay, but you really don't know, you know, how much this is going to be or even why. Now, if you have a different situation where someone's taking this for like a course of treatment, that's regular schedule, and like for appointments and sessions like that, you actually can request in that situation that you have to grant them the leave, obviously, but you actually can request that they schedule it at certain convenient times, you know, during the day, to try to work around work, or, you know, maybe later or something like that. So there is some flexibility there that wouldn't be deemed interference, but that's just that only in that situation. Now, what happens if you doubt the leave? When someone makes a request for FMLA, they give you a doctor's note sometimes. It can be different ways, verbal, doctor's note, or whatever. They indicate they need this, and you need to give, it triggers your obligation to give them a leave packet and everything and start that whole process. You have the right to ask for a certification. You don't just have to approve it. And the certification, you know, basically, as I was mentioning earlier, the doctor would certify this person has or a serious health condition and qualifies for the leave they requested. You can ask for that. It's a way of confirming it and getting the doctor, you know, to verify that this is actually legitimate. Now, what if you don't buy that? And this has happened sometimes. What can you do? Can you call up the doctor and ask for an permission? No, you cannot do that. Not in California. because we just have stronger privacy protections than you have under federal FMLA. The only time you can actually call the doctor up about a verification is if you doubt that it's authentic. And I've seen that happen. That is rare, but we did have a case where this thing did not look like it was really from the doctor, signed by the doctor, and called the medical office, and they said they could not confirm that the doctor had issued it. But what happens now if you don't have that situation, but you doubt that the person really qualified, you can't just deny the leave, okay? And say, we don't believe this, because you can't ask the conditions. Now, what you can do under federal and California law, you can ask for a second opinion. California will let you do that. You've got to have a reasonable basis for actually doing that. Sorry, trying to get back to where we were here. And so what happens when that happens? This does not actually happen often. I've only had this a few times over the years where the client actually doubted so much that this person really had a legitimate reason to be asking for FMLA and CFRA leave, that they asked for the second opinion. You would get to choose the doctor. It's at your expense, and the employee goes and this doctor examines them. But what response do you get? You actually don't get saying, oh, this person, really has this condition or whatever, or this is what it is, or they don't have this. You don't get any health information. The second opinion will just say this person does or does not have a serious health condition. What has happened a lot of the time too is it actually confirms. This is what I've seen. It tends to confirm what the first one said. So then what happens if there's a disagreement? The second opinion actually says, no, this person doesn't. It can go to a third opinion. And of course, if that happens, then whatever that third doctor says would control. And then a bigger issue here is, what if you actually suspect that the person's basically engaging in fraud? They don't have a condition or something like this, and they really don't qualify for leave. What do you do? This has been a question that really the law hasn't resolved too well. There are some federal FMLA cases that say if you've got a good faith belief that the person does not qualify and they're abusing it, you could deny the leave and basically terminate. And California had not recognized that and doesn't expressly do that. The current CFRA regs that were revised a few years ago actually do talk about, the employer can take action, but the burden is on the employer to prove it. So you can't just go on a gut reaction saying, I think that she really doesn't really qualify for this, and she's just sitting at home, and we see her out and about. It doesn't. That's one of the things too. I've noticed over the years, people will see, well, the person was doing something, and it doesn't necessarily mean the way the leave requirement's been interpreted. Someone could have a qualifying condition, and it doesn't mean they still can't do some activities. It doesn't mean they should be in bed all the time or just sitting at home. They can be out and about. It doesn't mean that there's fraud or abuse going on. So you actually have to have something really concrete. And there's been cases where people have followed people and have people in surveillance trying to come up with things like that. You really have got to have some solid information, not just speculation. One thing I always point out to people about how protective the law is of employees in this area is you had this case that there on the bottom of the screen because Federal Health from in Sacramento, where you had an emergency room nurse who had taken CFRA leave, and the hospital. And apparently it was for, she indicated she couldn't work, but I think it was stress, and there were some, emotional issues going on, and was on leave saying she couldn't handle the job. So the hospital comes to find out that while she's on leave, she's taking the job. Now you think on one hand, someone working, anywhere while they're supposed to be on leave, that's a problem. This person probably doesn't qualify. In this case, not only was this nurse working while she's on leave, she's working as a nurse at another hospital. And she's argued, well, the difference was she's an emergency room nurse at Federal, but she's not doing emergency work somewhere else. And the California Supreme Court, what did they say? They said that could be a plausible difference. and doesn't mean that she was necessarily committing fraud. There could be, if she had emotional issues or things going on and the stress of this, she couldn't handle that type of work, but she could handle some other nursing work. So that just is a perfect example of how protective this may be, and you really can't just go on a gut reaction and you think that someone is committing fraud.
Yeah, so SB 1383, what are the changes? So this is the new law that is effective January 1st of this year. And so the main changes to CFRA include the following, and we're gonna go through these in detail so we can kind of explain what exactly these changes are. But the first one is it extends CFRA to smaller employers. That's gonna have a significant impact. More family members are added, and we'll see how that kind of contradicts and expands what FMLA requires. Qualifying exigency is included for military-related leaves of absence with one important distinction between FMLA and CFRA that we'll go over. And then the often confusing key employee exception is eliminated. And so we'll also go through that as well. Okay, so who's covered under SB 1383? So covered employers have at least, so before January 1st of 2021, as Paul had mentioned, covered employers have at least 50 employees within that 75-mile radius of a location for CFRA to apply to employees at that particular location. What SB 1383 does is covered employers need only have 5 employees. So it significantly lowers the employee threshold, and it eliminates the radius, the 75-mile radius threshold. And so what the impact is an estimated 6 million California employees now will be covered and be able to utilize the FMLA or utilize CFRA. And so that's a significant expansion that SB 1383 complements. The next change is the expanded family members, and this is a big one. So currently, or before January 1st of 2021, CFRA allowed employees to take an unpaid leave of care for certain family members with a serious health condition. So Paul had gone through some of these, but it included family members, your children, your dependent children, your spouse, your partner, things like that. CFRA, SB 1383 significantly expands the definition of family member, and the expanded list of family members includes siblings, grandparents, grandchildren, domestic partners. But not only does it expand that, it includes adoptive, foster, biological, step-parent, step-child relationships. And so it significantly expands kind of what that definition of family member is. The second part is it expands the definition of children to cover all adult children and children of domestic partners. So previously it was dependent children. That requirement has gone away with, and so now it's any child that would cover under CFRA. And so as you can see, that significantly expands the definition of what was previously mandated by CFRA, and it expands the definition beyond what FMLA requires. And so we'll talk about kind of what that means as it relates to leave under FMLA and CFRA and some of the stacking issues that could occur. The next is the qualifying exigency is added under SB 1383. So this tracks with the FMLA, where the FMLA allowed active military duty or the call to active duty by an employee's spouse, domestic partner, child, or parent. That was allowed by the FMLA with one important distinction. Domestic partner, that wasn't previously, that's not required under FMLA. Under CFRA it would be. So this change essentially conforms with the FMLA with exception to just that one exception where it allows a state registered domestic partner to be covered under a qualifying exigency leave.
Okay, and one change that the new law made with CFRA is this key employee provision is gone in California. It still is under FMLA. And just what I want to say about this is it's probably a good thing because it was rarely used. There's hardly any law out there that interpreted it. And it really just confused people that were trying to administer family medical leave. Many of you may have seen on the forms, if you're using them, is this person is or isn't a key employee. It doesn't mean that they're an important employee in the organization or something like this. What this means is that if the person is a key employee, and it's really hard to figure out who actually is that because you have to look at their pay level within a certain area and stuff like this. You actually, if you could designate someone as a key employee and give them a leave, but you're basically saying, we're not going to reinstate you and we don't have to. And the employer would have to demonstrate that there'd be substantial economic injury if somehow they had to do this. What has happened, it just really confused people. And over the years, I had people like, was this person a key employee or not? And I'm like, you don't even have to answer that unless you are planning to rely on that to try to deny reinstatement. I've also seen people think that somehow if they could put someone as a key employee, they can deny leave, which is wrong. They get the leave, the continued benefits, but they would not have to be reinstated. Well, this is gone in California, so you don't need to worry about that anymore. And they just want to take it off of your leave approval paperwork or your notice of rights and responsibilities paperwork. So, Jeff.
So why does SB 1383 matter to employers? Well, importantly, it lowers the threshold of employees, so it makes more employees eligible for CFRA. That's going to be a burden for smaller employers that have never dealt with this. There's going to be administrative issues, right? So first timers, more employees are eligible, so that means more tracking of leaves, more paperwork, and so there's going to be complications related to that. There's also going to be how to address the workload or hire someone when an employee is out on CFRA leave. The work goes on, right? And so finding kind of the ability or somebody else to take over that workload will be important. There's going to be liability exposure because as we know, plaintiffs' attorneys won't miss a beat with anything that they could pursue. And so we expect that there's going to be an uptick in discrimination or retaliation claims from some employers that won't necessarily track with SB 1383. And so that'll be an issue. There is a mediation pilot program that involves first using the DFEH free services of mediation for employers that have only 5 to 19 employees. So if they receive a right to sue letter, they first have to go through this step at the employer's discretion. And so that could be a way to kind of resolve cases early on. But like I said, it's limited to just employers with 5 to 19 employees. There's going to be stacking issues. We're going to discuss this in a little bit more detail later on, but FMLA doesn't have that expanded family definition. And so there's going to be circumstances where an employee is eligible for CFRA under the expanded definition, and FMLA, they don't necessarily qualify for. So there's an opportunity or a potential that somebody could take potentially 24 weeks of leave. And so we'll talk about the stacking issues, but that could be an issue. I know that this is a lot. Hopefully you're not too stressed. We're going to discuss kind of the mechanics of FMLA and CFRA so that employers can be compliant as far as what steps they have to do in order to kind of notice it and so on and so forth. So let's get into that. So the first step is notice. So do employees have to notify employers of their need to take leave and when they plan to take leave? Yes. Now, do employees need to say that they need to take FMLA or CFRA leave? They do not. Do they have to say any magical word that employees to provide that notice to employers regarding their need to take FMLA or CFRA? There's not. There's not going to be magical words. They don't. And so oftentimes this will come up in circumstances where I have a health condition that will keep me out of work for 2 weeks.
Yeah.
It would qualify as notice and you'd have to go through the steps. I need to go to the hospital for my health. That one's a little bit more obvious, but that would trigger it without using the words FMLA or CFRA or any type of request for leave. My brother had a stroke. again, that could also qualify, right? And so that's just something that employers should understand is employees, yes, they have to provide notice, but the requirement of what they have to provide notice for could really be anything. And so employers need to be kind of aware of that. And if they see and hear something that would trigger that, then they should pursue kind of whether or not FMLA or CFRA would be appropriate in those circumstances.
Yeah, and Jeff, just one thing there too. I mean, I think it's really important to emphasize again that there are not magic words. They don't have to. The regs are clear. You don't have to even mention family medical leave, FMLA, CFRA, any legal provision or anything like that. It could be I have something going on. I'm going to need to be off. Something like that. This test is really anything that would put the employer on notice. You know that there could be a need for this, and sometimes some things it's not even things that people say. If you've got someone that is having repeated absences, you know, for I'm not just calling out for just a day here or there, but they're out for an extended period and they've gone 3-4 days on sick leave and things like this, and you don't know how long they're going to be out, or they're saying they're going to need to be out more. They're not doing well. That could be enough to trigger it, and you know, you may just want to. There's usually not any harm in just sending the notice of eligibility by responsibility. You don't always get that back, but at least you can say we did provide the paperwork for them and we did what we're supposed to. Yeah, the worst thing that we've seen this a lot over the years too, Jeff and I, is you have a client that calls up and it's like, we don't know what to do about this situation. This employee has not been to work in a while and has just been absent. Well, do you know what's going on? Or you've gotten a note saying that this person's going to need to be out for this much longer. That should probably, if you get something from a doctor saying the person's going to be out, you know, for a while, even though they haven't asked for FMLA, that's enough really to trigger, I think, notice there. But what's bad is what we don't like to hear is, you know, but we haven't followed up. We don't know what to do, and this person's been out for weeks, and you know, we haven't sent paperwork or anything like this. You know, that's bad. So you have to try to catch up too.
That's a great point. And kind of my advice is when in doubt, if you're unsure, kind of pursue these next steps in order to determine whether FMLA or CFRA is appropriate under the circumstances. Don't just ignore it. Don't expect the employee to provide additional documentation. Be proactive, because oftentimes if you're not proactive, that could lead to issues down the road. So that's a great point. Proof may be required, the certification form. So this is an optional tool for employers to use to request information to support the FMLA and CFRA qualifying reason for leave. The main point that I want to focus on this slide is in California, employers can't inquire about the underlying health condition or the medical reason for the leave of absence, with pregnancy being the one area that's excluded. And so a common mistake is California employers will use the FMLA form, which asks for a diagnosis and health information. So I wanted to highlight that point is you can certainly use this optional tool to request additional information, but be sure not to be requesting information related to that underlying health condition or the reason for the leave of absence. And so here's the sample FMLA certification. The other point that I just wanted to briefly mention as well is it doesn't need to be this formal of a form. It could be a letter. It could be, it could be a variety of different forms, right? You could create your own form based off of this form, with the exception of you don't want to include the underlying health condition question. But it doesn't need to be some formal form. It could be a letter on the company's letterhead. And so that would be appropriate. Or oftentimes the medical provider like Kaiser will provide their own type of FMLA CFRA certification form. Oops. So what happens when there's a disagreement with a certification or you suspect that the employee is being less than truthful? I'm sure we may have encountered that issue. So one of the options is we can seek a second opinion. So Paul had kind of touched on this earlier, but under CFRA, an employer needs a good faith objective reason to doubt the validity of the first medical opinion. And then the second opinion can only be sought for the employee's own serious health condition. So what that means is good faith objective reasons, a higher standard, as you'll see from what the FMLA is, which they only need a reason to doubt it. So the standard's a little bit higher under CFRA. And then you can only seek a second opinion as it relates to the employee's own serious health condition, not a family's serious health condition. So that's a little bit different. Can you seek a third opinion? Yes. If the first and second opinions conflict, an employer may require and pay, importantly, for that third opinion. And so that is an option. And then can you request a recertification from an employee? Again, under the FMLA and CFRA, there's a distinction. And so we need to be aware of that. Under FMLA, it's not more than every 30 days or until the minimum duration expires from the original certification. CFRA is you can only request the recertification when the time provided by the healthcare provider has expired. So that's different, right? So FMLA, you can do it every 30 days. And under CFRA, you can only do it after that initial time period provided by the healthcare provider has expired and the employee requests additional leave. So that's an important distinction.
Yeah, and Jeff, that last point is something that has come up with some frequency because especially with intermittent leave, we've seen a number of situations where the clients actually kind of doubted, there's one of those where you get one of those vague intermittent leave certifications where when the person's condition flares up, whenever this happens, it could be 1 to 3 times a month, for 1 to 2 days at a time. You have no idea how or many times, if at all, this may happen or when. We've seen a lot of those types of intermittent leave certifications where it covers a period like a year ahead. And, basically you're like, well, can we ask, can approve it for like 3 months and ask for another one or 30 days? We'd have more flexibility under just FMLA, but, California is different. This is the key thing where it says you have to go by that time limit there with that year. So if that's what it said. So you have to look at, okay, do we doubt this and do we have enough reason that we could ask for a second opinion? And it gets back into that. One thing too, I just want to highlight, we didn't mention this too, you can submit questions to us. I see we've been getting a few and we are going to answer those. Some of them we may cover in some things coming up, but we'll answer them at the end or as we go along even. We have just a little bit to go. We're almost near the end, but keep sending them. We'd love your questions. We didn't mention that earlier.
Absolutely. Just one last point before we move on is in some circumstances you'll have an employee submit some type of certification or medical note from a dentist, right, for a condition that a dentist wouldn't necessarily be involved in. Is that enough of a good faith objective reason to doubt the validity of that medical opinion? And the answer is probably not, right? And so yeah. That's an important distinction, is just because you might doubt the medical qualifications or kind of the reason why this individual certified the medical opinion, that on itself isn't by itself enough to kind of justify and doubt that reason.
Yeah, and Jeff, that's actually a good point. This is actually one of the questions that we've had submitted. I think we can answer this now. The definition, it has to be from the certification can be from the healthcare provider, and the regulations, they're very broad in how they define that. So the thing about a dentist, I have had that question come up, and it's like, oh, someone could think about it. Someone could have oral surgery and be recovering for days from that too. That could qualify. It's a course of treatment. Who knows? There could have been an overnight stay, or could qualify for it. That very well could qualify. Where you see this, where people question it, is to get some more holistic or alternative medicines, but they could qualify too. One question, this is one of them submitted to us, I think it's a good one. Does this apply to certifications from outside the country? They very well may need to be accepted. There is nothing in the regs that says it's got to be from a doctor within the state or even within the country. We've seen situations where someone submitted a certification for their themselves for their own leave, and it was from a provider out of state. Someone could be going out of state for surgery or for treatment or something. They could even be going out of the country. And what has come up a lot, we've seen this a number of times over the years, where people have gone and taken leave. They've left the country to take care of a family member who was having a serious health condition. Can they do that? Yes, they can. That could qualify. It doesn't say it's got to be here in the state or local or anything like that. And you still have the right to ask for a certification. And again, nothing in the reg says it's got to be from someone here. I did have a case, we had a case a few years ago where this actually was the DFEH, and someone had said they'd been denied leave when they'd actually had to be given leave. And we actually had accepted a certification from a doctor in Mexico, and we were able to show that to DFEH. Yeah, those could qualify. What I've always told people too is, because this has happened with a lot of companies where they have people that go and they have employees that have done this multiple times, and it's like every year, a couple of years, and in fact they're going on vacation is what the client really suspects is going on when they say they're going to take care of a relative. And think about some of the things we talked about. It's not just going to visit someone who may be sick. Are you needing to be there to provide care? That's one of the tests. And, can you get that certified? What I have recommended too is ask for the certification in that case. Even if you get one from out of the country, see if you get one. Because if you don't get one, then the person is not within the protection of the FMLA or CFRA. So you may be able to deny leave that way. Or the other thing is too, I've also told people a way to approach it is, because sometimes people, we've had clients where people go for not just the 3 months, it's longer than that. And then they come back and want their job back. And they're like, do we have to reinstate them? What I usually recommend too sometimes, get the certification or just go ahead and approve it based on what they told you. Run out 12 weeks. If they haven't come back, and then you don't have to reinstate them. If the leave was for a family member, they either have to come back at the end of that, or you don't have to hold their job anymore. So there's a couple ways to address those issues when they come up. Okay, again, the approval and designation process. There is a time limit under California and law and the FMLA that you need to respond after you get the certification within 5 business days. Saying either we approve it, or we need further information. We're going to ask for a second opinion, whatever that is. Sorry here. The wonders of working virtually and remotely here. Okay, now the approval, you have to give an approval and designation in writing. There are forms that you can use that people have that that are available that or have created, or they've worked with their attorneys to create them that have the different points. And sometimes this can be complicated because you've got to put in the approval and designation how much you're approving and the period, and also that you're designating this as under FMLA or CFRA or both. And that can be a challenge here because they don't match up with the types, the reasons that people can take the leave anymore. So definitely your forms probably need to be updated that way. One very, very important requirement is that CFRA in California, it requires that when you approve someone for leave, you actually have to put in there that you guarantee their reinstatement to the same or comparable position. If you don't do that, then the leave shall be deemed not to have been granted. And think about that. You could actually have the person goes and they take the leave, but another way this has happened too, that language not being there, or you have someone that was given the leave, they take all the leave and you never gave them the approval, or you didn't give them any paperwork. Did that count? The laws of the regs actually say no. So basically they're getting free leave, and after that they could still be eligible to take the full 12 weeks even though they've already had it. So these are very important points, to make sure that all those steps are followed and that language is there. One question that has come up is retroactively, can you designate this? And that's basically the person's been on leave and for whatever reason, there's been a delay for you didn't designate it, okay? And before the DOL actually had said that wasn't allowed. So basically someone could, again, be out there for an extended period, and since this wasn't timely designated, you had it didn't count. They still had their full leave out there. The regs have been updated in California and under FMLA to say retroactive designation is okay as long as it really doesn't prejudice the employee and the person hasn't returned to work. So that's something to remember. You know, if it wasn't done, you still could probably catch up and send them a one saying we're designating this, even though it may be a little late, as long as the person hasn't come back. Now, what if the employee won't return the certification here? This does happen. You're supposed to give them at least 15 days to return the certification. And you do have to be a little flexible. It doesn't mean that you get to day 16 and they haven't returned it and you just say, oh, too bad, denied. You definitely want to follow up with them. There are some times where people have delays getting things from the doctor, getting them returned. And that has especially been true in the past year or so. In fact, we've had clients in a lot of cases just decided they weren't going to ask for certifications. They had enough information, they thought otherwise that the leave requests were legitimate, they were just going to approve it. Just recognize the reality with COVID-19, it's hard to get in, you know, or see people or to get things back quickly. So if someone doesn't return it, the regulations are clear under federal and California law that the person is not within the protection of the law until they do. So basically means it doesn't qualify as CFRA or FMLA leave. What you want to do is to set this up. You have to give people a warning about what may happen and what the consequences may be. And we've done this a number of times. The clients reached out to them, called them, we sent them letters, tried to follow up. And sometimes people will string them along. Oh, I'm getting this, you know, I'm going to have this next week, and it just doesn't happen. We've put people on notice and said, you're on an unapproved absence. And if we do not get this by a certain date, we reserve the right to address this under our policies, which basically is it's unapproved, you're absent without authorization, and your job will end. And that has happened, and the law would allow that. One thing I do want to point out, you have the right to ask for a certification. You don't have to. It's possible that, and you can put this in your notice of rights and responsibilities when someone asks for FMLA, so you give them the paperwork. You could check the box, we need a certification from you, or we don't need anything further from you, we're just approving it. Because the reality is sometimes, you know, even though you don't have the right to know the condition, you don't have the right to ask, a lot of employees share information too. They'll tell you, I'm going to be having heart surgery. We had one where I'm going to be having brain surgery. There's no doubt about that. Or you know the person is ill and you don't really have a doubt about it, or they've been in an accident, they're in the hospital. You know, it's not really a question there. So it doesn't necessarily make sense to get a certification and put them through the paces. I've seen people make mistakes too, where they say, oh, it's approved, but we also want a certification. No, it's one or the other. So that's one thing to think about. You don't have to do this. It's just in certain cases where you think you may need it. Now, one thing about designating it when you approve it, a lot of times this will be easy, but let's say the person's out for their own serious health condition. That's going to qualify simultaneously for CFRA and FMLA leave. But not always, as we've seen, because California has a lot more leaves that don't qualify under FMLA. So you've got to try to figure that out. This is going to be administratively a burden to track because you're thinking, okay, the person just doesn't have a bucket of just 12 weeks. It's 12 weeks that could total that could be under both, or think of it this way. Someone could go take 12 weeks of leave or take 6 weeks of leave even to take care for their brother, okay? So they would have 6 weeks left under their California family medical leave for that year. How much do they still have under FMLA? 6 weeks? No, that doesn't qualify. It only counts against California because it's a California leave. They still have 12 weeks of FMLA. We've seen this before because California allowed leave to care for the condition of a domestic partner, where people had taken that, but they didn't use their FMLA because that wasn't an FMLA recognized leave. So they still have the 12 weeks. There's going to be a lot of that here, and trying to sort this out and make sure it's all designated correctly if it's an FMLA or CFRA or both. That's going to be a challenge for people. Okay, I believe this is yours, Jeff.
Yep, pregnancy disability leave. Just a couple points that I wanted to reference here. FMLA pregnancy is considered a serious health condition. It runs concurrently with pregnancy disability leave, the FMLA does. And then you do the same process of approval and designation of the FMLA leave that we've discussed. Under CFRA, pregnancy is not considered a serious health condition, so it doesn't run concurrently. Rather, CFRA provides the parental or baby bonding leave up to 12 weeks. So that's an important distinction. And then SB 1383 expands parental or baby bonding for employers that employ both parents. So before, rather than having only a combined total of 12 weeks between those two parents for the leave, both parents can take up to 12 work weeks for the baby bonding time. So that's an important distinction if you employ parents of children who would utilize the pregnancy disability leave.
Yeah, and Jeff, just a question on that. We had one submitted. I think it would be a good point to take that. And again, this is something where there's a lot of confusion. And let me tell you, we've had clients that are outside of California. And they have California employees, and trying to get them to understand how pregnancy disability leave works and reconciling that with FMLA and CFRA can be challenging. So just in a nutshell again, CFRA doesn't cover pregnancy, FMLA does, okay? So you could be taking, you have an employee that's out for pregnancy and starts the leave. So the first, 3 months of that, could run, it would be under FMLA, but it doesn't run concurrently under CFRA. That still sits out there. So, but what California does have is an employee is allowed up to 4 months for pregnancy disability leave, okay? So think of it this way. Let's say the person takes that 4 months. Okay. That first 3 months of that is going to run concurrently with the FMLA, not with CFRA. So you have the pregnancy disability and FMLA going concurrently for 3 months. And then the 4th month of the pregnancy leave would just be PDL, pregnancy disability leave in California. They get to the end of the pregnancy leave, and then the CFRA baby bonding time is still out there. So this is why, some people have been flabbergasted by this. You have an employee that was pregnant, has a child, could be gone for a total of 7 months, and this would be legally protected. And we've seen people do that too. I've had some, the pregnancy disability leave is up to 4 months. We've had some clients, almost get stuck on this about, well, how long is the disability really going to be from pregnancy? And that's the situation where, after someone could have had a complicated pregnancy or birth, when does the disability end? When do they really recover? And it's not always clear, okay, Wednesday they were still disabled, Thursday she's not. And so a lot of times, you have to go with what the doctor and the employee say on that and what they certify. But a lot of employees do take the full 4 months. It depends too on how long people want to be away or feel they need to be away, or what the doctor will certify, or can they afford to be away? But they could be gone for that long. And the good question here that we were asked, okay, we have the separate leave, and then is it even for registered domestic partners? Well, the pregnancy leave wouldn't be, because the pregnancy, that is just for your own condition. It's for pregnancy, childbirth related condition. Okay, but the baby bonding leave, that is for the birth, adoption, placement of a child. And of course, mothers and fathers are able to take that. And of course, CFRA treats registered domestic partners the same as a spouse or another parent. So if you are actually having a child with your registered domestic partner, likely you would qualify for the baby bonding leave. Do you think that's right?
Yep.
Okay.
Yep.
Okay, next.
Okay, so California paid family leave. So just real quickly, I just wanted to highlight this. There are 2 life events that qualify for the paid family leave. And importantly, paid family leave, that it provides partial pay to employees. It's not a protected leave. It's just a monetary benefit. However, your job may still be protected through FMLA or CFRA. So just wanted to highlight that because the way that it's named, California paid family leave, causes confusion. So essentially there's 2 life events that qualify for the paid family leave, which is again a monetary benefit. One is bonding. You welcome a child into the family through birth, adoption, foster care, and then caregiving, where you care for a child, a parent, a grandparent, and so on and so forth. The paid family leaves pays claimants approximately 60 to 70% of their pay, and that eligible California employees may file a claim for the paid family leave through the state of California's Employment Development Department's Disability Insurance Branch. The nice thing about this is you direct employees to where they have to file, but employers don't have to take kind of that laboring oar of getting employees approved and going through that process. That's going to be all through that state department. So just wanted to highlight that point. What happens if an employee runs out of leave but still needs more time to return? I know that there's been a couple questions on this. Are those employees out of luck? No. Let's avoid the 12-week termination problem. Sometimes we'll see the 12 weekends, and then on the very next day or a couple days after that, the employer moves forward with the separation. Again, that can raise concerns of retaliation, discrimination type of claims. And apart from that, there's disability protections that could require more leave as a reasonable accommodation. And so you have to engage in that process.
Yeah. And just a note on that, Jeff, too. This could apply not only after someone runs out of their family medical leave, if they need to be out. This is only for their own condition, not to take care of family members, but for their own condition, it could be an accommodation. But there's other times too, if someone isn't eligible for FMLA for whatever reason, there's not enough, they're not worked for a covered employer, or they haven't worked there long enough, they haven't met the year requirement, but they need to take something leave for a disability. This could also apply. And when we say interactive process, that is where, let's say you get a note saying this person needs to be out for 3 more months. Okay, that could be a reasonable accommodation here because it is for a definite period. If it's an indefinite leave, that doesn't qualify as a reasonable accommodation. That's one of the things you definitely want to figure out in the interactive process. And what that is usually I recommend you give a letter to the employee and say, we're treating this as a request for accommodation. We want to do an interactive process. Have your doctor answer these questions, because we're outside of FMLA here. You actually can inquire about this because you do have to decide, is this a qualifying disability? And what does the doctor recommend and why? Okay. And so you're in a different realm here, and the employee, would sign a release so the doctor can answer the questions. And so you actually do find out what the condition is and what the doctor recommends, which can be a lot different than what the employee tells you. Let me tell you that. And you definitely want to ask, is the maximum duration of the leave known? And because if they go and say, we don't know, unknown at this time, or, you get some sort of vague answer. It's indefinite. If they say that, or the employee confirms to you that they have no idea when they can come back, then you can actually deny further leave. It's not a reasonable accommodation. But if it's for a definite period, it's like 2 weeks, 2 months, or something like that, that would qualify. There is a possibility of arguing there's undue hardship. That is an exception under the disability laws that would apply here, but that's very, very hard to prove. It's not just inconvenient. You've really got to make a strong showing on that. Okay, I believe here. Okay, just a note about some of the coronavirus issues, and as this relates to the family and medical leave. As many of you know, there was a big change in the past year with the Family First Coronavirus Response Act, which created a federal paid sick leave benefit for 80 hours for certain employers. And then you had California later enacted one that covered larger employers that weren't covered by the federal law. But separate from that, there was expanded family and medical leave under federal FMLA that became available. And in some cases, some people or employers have never been covered by it before, had to provide that. So it just expanded the reasons why people could take it. If they had to take care of their kids, the school was closed because of coronavirus, for example. But what it didn't do, it just was an expanded reason. So if someone had they still wouldn't get more than 12 weeks in a year. So where this stands now, this law actually, the federal law expired on December 31st at the end of the year. There's proposals in Congress to revise that. And it's hard to tell what actually is going to happen. I mean, it looks like the proposal that was coming from the president was going to propose allowing up to 14 more weeks of coronavirus-related leave. So basically, I think what they were envisioning is 2 more weeks or 80 hours of paid federal sick leave and up to 12 weeks of expanded FMLA, which would be paid under the proposal they were considering. And they were planning to give the proposal that I saw was to give employers a tax credit for that. So most would actually not have to pay the cost. And then the proposal on the federal level was to actually allow up to $1,400 a week for that, which is a lot. But of course, that's going to have to go through Congress. We ultimately don't know what will happen. I will predict that probably something further will be enacted on the federal level for expanded FMLA, things like that. And then in California, separately, we had the supplemental paid sick leave, and there was also a provision, for food employees. All of that was in AB 1867. That expired at the end of the year. And so there's proposals in the legislature too to reenact that in some form or expand it further in California. So we'll see what happens with that. One interesting note, we talked about leave, is it simultaneously qualifying as FMLA or CFRA? You think about this, the federal expanded FMLA, if people were taking that because, they were taking care of someone who was isolating or quarantining, or because their child wasn't in school, that would have taken care of any FMLA eligibility they had for that 12 months, but not CFRA, because that wasn't a California leave. So their CFRA leave would still be out there. And one other point too, because this has come up about just on COVID issues, does it qualify for FMLA and CFRA leave? And the answer is it could. It depends on the circumstances. Obviously, where it would qualify is if, let's say, the person is sick with coronavirus and they develop a condition that's a serious health condition, say you have COVID, you get pneumonia. That would qualify, obviously. Where the questions have come up, though, we've seen this with clients, where people don't want to come to work because they feel they have an underlying condition that makes them at higher risk, or people are just afraid to go out. They don't want to risk being exposed. Does that qualify for taking family medical leave? No. The DFEH in California and the federal DOL have both taken the position that it does not qualify. That in and of itself is not a serious health condition. The person may have a serious health condition regularly, but doesn't require leave, okay? But the fact is they wouldn't be taking it for that reason. It's just because they feel they're at higher risk. They said that in and of itself is not a serious health condition. There's kind of a fine distinction there. The thing, though, to consider is this probably will come up is as this thing goes on, is that some of the people who are actually maybe at higher risk because of an underlying condition may qualify for accommodation as a disability. If the underlying condition is a disability and they're at higher risk, the DFEH was clear on that could qualify. You need to do an interactive process, but it's not going to qualify for FMLA. And one of the interesting things, too, if you think about this, we talked about a reasonable accommodation leave has to be for a definite period. You could actually see the way things stand now. If someone wants leave as an accommodation because they're at higher risk, for their disability condition, and they don't want to risk exposure, how long is that really going to last for under current conditions? I don't know, anybody could say. So that could be an indefinite leave, which is not an accommodation. So that's all the more reason to really do an interactive process in that situation. Okay, and I believe this is like the end, Jeff.
Yes. So just
okay. So yeah,
and then we'll get into the questions. Do you do the slide, or do you want me to, Paul?
Go ahead.
Okay, yeah, so what to do now? Don't leave these issues for later. It won't get better with time. The new law is in effect since January 1st. And so the time is now to kind of update policies, update the CFRA posters for the workplace. You can visit that website in order to obtain kind of the most recent notices, update FMLA and CFRA paperwork, the notice, certification, make sure that it's not asking for the health, the condition or anything like that, medical condition. And then we've included a summary summarizing SB 1383. And so check that out, and that'll kind of expand and go over kind of what we've discussed today. And then if you have questions, talk to legal counsel, right? Because oftentimes we can avoid some of the issues that could come later as far as litigation and whatnot if we're involved kind of at an earlier stage. So that's kind of what to do now. And we have some questions, I believe, now.
Yeah, I think we have covered most of them. There was a couple we didn't that we want to. Someone was asked, "Will we be getting a copy of the presentation? Can we get that?" And the answer is yes. I believe XSafe, they were posting it or could send that out to you, but we did make that available so everyone could get a copy. If not, just you can email us. One question here is, and I can understand the confusion here about pregnancy again and everything, and CFRA and FMLA, and what qualifies for what when there. And the question is, can it be taken concurrent? Can FMLA and CFRA be concurrent when there's a new baby? And this is something, a question a lot of people have. Let's be honest about it, because again, FMLA says that pregnancy is a serious health condition. It is not under CFRA, because you get the PDL leave, the pregnancy disability leave for that, and then the baby bonding under CFRA stays out there later. So the only time that would, so if the leave is actually for pregnancy disability, you're out for pregnancy, that is not going to run concurrently with CFRA, and FMLA will not run concurrently then, because the pregnancy leave is going to apply the same time the FMLA does to cover the pregnancy disability period. Then, of course, the CFRA stays out there for baby bonding. Where they could run concurrently, think about this, if you have the father, the non-birth parent, okay? Or if you have adoption, okay, because you don't have an employee who's pregnant, you could have place them a foster child or an adopted child, okay, and you take the leave for baby bonding, that would run concurrently under both of them. Do you think that's right, Jeff?
Yep.
Let's have the pregnancy things to take a chart to get through here. Now, one question, just a big one. Does SB 1383 cover parent-in-laws like the California paid family leave or not? No, it doesn't. This is one of the things that there's been some confusion about this. And one of the things that is interesting is along the lines in the legislative process, this has been something that had been considered, and there was some sloppy drafting in the bill. There was actually in the definition section, the definition for like parents-in-law or something like this. Is there a reference to it anywhere in the bill? No. When it actually talks about who the covered family members are you can take leave for, it's not there. So that's actually something I think that they intended to take out. It shouldn't have been there. So at least at this time, it's not covering in-laws.
And parent has been defined so it's not only biological relationships, but adoptive, foster, step-parent, guardian, legal ward relationships. So that definition is expanded, but Paul's right, the parent-in-law, it would not be. Yeah,
and it's so broad because it has step relationships, and there's a lot of that. People extended families, so it could be step-grandparent, and that's so step-parent, it could be covered there, step-brothers, sisters too. There was another one here, make sure that we covered. Yeah, Jeff, the qualifying exigency under CFRA covers domestic partners, okay? Does it also cover children of domestic partner or just own children? And on this one, I think it would cover, because that's to care for family members. So someone takes that and, it's for children. And of course, the definition of child, under the does include child of a domestic partner.
Yep, that's right. So it would cover it. Domestic partners would kind of cover it.
Okay, I think that we've covered all the questions we had there. So thank you everyone for those questions and for staying with us. You know, there's a lot to cover here, and we appreciate everyone, you know, interest in staying with us. And again, thanks to AgSafe for hosting us today. If you have any questions, you can email us, and also our alert on this law is on our website too, if you want to look that up. So again, let us hear from you if you have any questions or anything. So, and again, thank you very much.
Thank you,
everyone.
Paul and Jeffrey. This is Angelina over at AgSafe. I want to thank you both for doing this for us, and hopefully this is the first of many again, free webinars. Yes, we will be posting the recording and are happy to send over a PDF version of the PowerPoint presentation as well. If anyone needs anything or needs to contact us, please contact us at AgSafe, safeinfo@agsafe.org. Thank you.
Okay, thanks again.
Thanks,
Take
Paul
care.
and Jeffrey. Bye.